Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Jones v. Hendrix. In this case, the court considered this issue. May a federal inmate who did not challenge their conviction on the ground that the statute did not criminalize their activities subsequently apply for habeas relief after the Supreme Court retroactively invalidates the circuit precedent on which the inmate relied in not challenging their conviction? The case was decided on June 22, 2023. The Supreme Court held that Section 2255E does not allow a prisoner asserting an intervening change in interpretation of a criminal statute to circumvent the Antiterrorism and Effective Death Penalty Act of 1996's AEDPA restrictions on second or successive Section 2255 motions by filing a Section 2241 habeas petition. Justice Clarence Thomas authored the 6-3 majority opinion of the court. The majority first clarified the relationship between Section 2255 and Section 2241 in the context of federal prisoners challenging their sentences. Congress introduced Section 2255 to allow prisoners to challenge their sentences in the sentencing court, rather than through a habeas corpus petition under Section 2241. While the saving clause in Section 2255E preserved access to Section 2241 in specific situations, the Antiterrorism and Effective Death Penalty Act (AEDPA) added restrictions on second or successive Section 2255 motions. The saving clause does not permit prisoners to circumvent AEDPA's restrictions, even if they are challenging a new interpretation of a criminal statute. The majority found unpersuasive arguments by both Jones and the federal government regarding when Section 2255 might be considered inadequate or ineffective, thus allowing recourse to Section 2241. AEDPA's restrictions reflect Congress's deliberate choice to balance finality with error correction in the justice system. Justices Sonia Sotomayor and Elena Kagan jointly dissented, arguing that Jones presents the precise type of mismatch contemplated in Section 2255H, and would thus remand for the lower courts to consider his claim under the proper framework. Justice Ketanji Brown Jackson authored a dissenting opinion arguing that Section 2255 requires that Jones's petition alleging legal innocence should have been considered on the merits. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. This case concerns the interplay between two statutes, 28 U.S.C. Section 2241, the General Habeas Corpus Statute, and Section 2255, which provides an alternative post-conviction remedy for federal prisoners. Since 1948, Congress has provided that a federal prisoner who collaterally attacks his sentence ordinarily must proceed by a motion in the sentencing court under Section 2255, rather than by a petition for a writ of habeas corpus under Section 2241. To that end, Section 2255E bars a federal prisoner from proceeding under Section 2241 unless the Section 2255 remedy by motion is inadequate or ineffective to test the legality of his detention. Separately, since the Antiterrorism and Effective Death Penalty Act of 1996, AEDPA, second or successive Section 2255 motions are barred unless they rely on either newly discovered evidence or a new rule of constitutional law. A federal prisoner may not, therefore, file a second or successive Section 2255 motion based solely on a more favorable interpretation of statutory law, adopted after his conviction became final, and his initial Section 2255 motion was resolved. The question presented is whether that limitation on second or successive motions makes Section 2255 inadequate or ineffective, such that the prisoner may proceed with his statutory claim under Section 2241. We hold that it does not. In 2000, the U.S. District Court for the Western District of Missouri convicted petitioner Marcus D'Angelo Jones of 2 counts of unlawful possession of a firearm by a felon, in violation of 18 U.S.C. Section 922G(1) and 1 count of making false statements to acquire a firearm, in violation of Section 922A(6). The Court of Appeals for the Eighth Circuit affirmed his convictions and sentence of 327 months imprisonment. After losing his appeal, Jones filed a timely Section 2255 motion to vacate, set aside, or correct his sentence, which resulted in the vacatur of one of his concurrent Section 922G sentences but no other relief. Years later, in Rehife v. United States, this court held that a defendant's knowledge of the status that disqualifies him from owning a firearm is an element of a Section 922G conviction. In doing so, it abrogated the Eighth Circuit's contrary precedent, which the Western District of Missouri and the Eighth Circuit had applied in Jones's trial and direct appeal. After rehafe, Jones hoped to leverage its holding into a new collateral attack on his remaining Section 922G conviction, but rehafe's statutory holding satisfied neither of Section 2255H's gateway conditions for a second or successive Section 2255 motion. It was neither newly discovered evidence nor a new rule of constitutional law. Unable to file a new Section 2255 motion in his sentencing court, Jones instead looked to Section 2255E's saving clause, which provides that a federal prisoner may file a petition for a writ of habeas corpus under Section 2241 if, and only if, Section 2255's remedy by motion is inadequate or ineffective to test the legality of his detention. Invoking this clause, Jones petitioned the U.S. District Court for the Eastern District of Arkansas, the district where he was imprisoned, for a writ of habeas corpus under Section 2241. The district court dismissed Jones's habeas petition for lack of subject matter jurisdiction, and the Eighth Circuit affirmed. The Eighth Circuit rejected Jones's argument that the saving clause permits recourse to Section 2241 to present a Section 2255H barred claim based on an intervening decision of statutory interpretation, as well as his argument that foreclosing relief on his rehafe claim would violate the suspension clause, U.S. Const. Art. I. Section 9, cl. 2. In doing so, the Eighth Circuit deepened a split among the courts of appeals about whether prisoners in Jones's circumstances may resort to Section 2241 via the saving clause. We granted certiorari. The Solicitor General then noticed her intent to defend the Eighth Circuit's judgment but not its rationale. We appointed Morgan Ratner as amicus curiae to argue in support of the Eighth Circuit's reasoning. She has ably discharged her responsibilities. Consistent with the Eighth Circuit's reasoning, we hold that Section 2255E's saving clause does not permit a prisoner asserting an intervening change in statutory interpretation to circumvent AEDPA's restrictions on second or successive Section 2255 motions by filing a Section 2241 petition. We begin by considering the role of the saving clause in Section 2255 prior to AEDPA's enactment. We then consider the impact of AEDPA on the statutory scheme. In relevant part, Section 2255 provides a prisoner in custody under sentence of a court established by Act of Congress claiming the right to be released upon the ground that the sentence was imposed in violation of the Constitution or laws of the United States, or that the court was without jurisdiction to impose such sentence, or that the sentence was in excess of the maximum authorized by law, or is otherwise subject to collateral attack, may move the court which imposed the sentence to vacate, set aside or correct the sentence. An application for a writ of habeas corpus on behalf of a prisoner who is authorized to apply for relief by motion pursuant to this section, shall not be entertained if it appears that the applicant has failed to apply for relief by motion to the court which sentenced him, or that such court has denied him relief, unless it also appears that the remedy by motion is inadequate or ineffective to test the legality of his detention. In understanding the statutory text, a page of history is worth a volume of logic. Section 2255 is an outgrowth of the historic habeas corpus powers of the federal courts as applied to the special case of federal prisoners. The First Judiciary Act authorized the federal courts to grant writs of habeas corpus for the purpose of an inquiry into the cause of commitment, with a proviso that such writs could extend to prisoners in jail only where they were in custody, under or by color of the authority of the United States, or were committed for trial before some court of the same, or were necessary to be brought into court to testify. In 1867, Congress expanded the federal court's habeas powers to cover all cases where any person may be restrained of his or her liberty in violation of the Constitution, or of any treaty or law of the United States. For most of our nation's history, a federal prisoner claiming the right to be released in a collateral attack on his sentence would have relied on these acts and their successors. That changed with the 1948 recodification and reorganization of the Judiciary Code. In enacting the present Title 28 of the United States Code, Congress largely recodified the federal court's pre-existing habeas authority in Sections 2241 and 2243, which, respectively, confer the power to grant the writ and direct the issuing court to dispose of the matter as law and justice require. At the same time, however, Congress created Section 2255 as a separate remedial vehicle specifically designed for federal prisoners' collateral attacks on their sentences. The sole purpose of this innovation, as this court acknowledged a few years later, was to minimize the difficulties encountered in habeas corpus hearings by affording the same rights in another and more convenient forum. Experience had shown that processing federal prisoners' collateral attacks on their sentences through habeas proceedings, and therefore, through the judicial districts in which they were confined, resulted in serious administrative problems. Most significantly, a federal prisoner's district of confinement was often far removed from the records of the sentencing court and other sources of needed evidence. These difficulties were greatly aggravated by the concentration of federal prisoners in a handful of judicial districts, which forced those district courts to process an inordinate number of habeas corpus actions. Section 2255 solved these problems by rerouting federal prisoners' collateral attacks on their sentences to the courts that had sentenced them. To make this change of venue effective, Congress generally barred federal prisoners authorized to apply for relief by motion pursuant to Section 2255 from applying for a writ of habeas corpus under Section 2241. But, in a provision that has come to be known as the Saving Clause, Congress preserved the habeas remedy in cases where the remedy by motion is inadequate or ineffective to test the legality of a prisoner's detention. Traditionally, courts have treated the Saving Clause as covering unusual circumstances, in which it is impossible or impracticable for a prisoner to seek relief from the sentencing court. The clearest such circumstance is the sentencing court's dissolution. A motion in a court that no longer exists is obviously inadequate or ineffective for any purpose. The Saving Clause might also apply when it is not practicable for the prisoner to have his motion determined in the trial court, because of his inability to be present at the hearing, or for other reasons. In addition, the Saving Clause ensures that Section 2255E does not displace Section 2241, when a prisoner challenges the legality of his detention without attacking the validity of his sentence. To give a few examples, a prisoner might wish to argue that he is being detained in a place or manner not authorized by the sentence, that he has unlawfully been denied parole or good time credits, or that an administrative sanction affecting the conditions of his detention is illegal. The briefs before us debate whether these types of challenges depend on the Saving Clause, or proceed under Section 2241 directly. It is difficult to imagine a case in which this logical distinction would make any practical difference. That said, were it not for the Saving Clause, a literal reading of Section 2255E might be thought to bar any application for a writ of habeas corpus on behalf of a federal prisoner, whether or not it challenged the sentence imposed. If nothing else then, Saving Clause guards against the danger that Section 2255E might be construed to bar manner of detention challenges, even though they are not within Section 2255's substantive scope. In 1996, Congress enacted AEDPA, which made significant reforms to the process of federal court post-conviction review for both state and federal prisoners. Most relevant here, AEDPA strictly limited second or successive Section 2255 motions to those that contain 1. Newly discovered evidence that, if proven and viewed in light of the evidence as a whole, would be sufficient to establish by clear and convincing evidence that no reasonable fact-finder would have found the movant guilty of the offense, or 2. A new rule of constitutional law, made retroactive to cases on collateral review by the Supreme Court, that was previously unavailable. Importantly, AEDPA left the text of Section 2255E unchanged, but AEDPA's new second or successive restrictions indirectly gave rise to a novel application of the Saving Clause. Mere months before AEDPA's enactment, this court decided Bailey v. United States. That case interpreted the offense of using a firearm during and in relation to any crime of violence or drug trafficking crime, in violation of then existing 18 U.S.C. Section 924C, 1, more narrowly than many circuits' previous case law. Under this court's Section 2255 precedent, Bailey's narrowing interpretation was grounds for a collateral attack by federal prisoners who had been convicted under the Courts of Appeals' broader interpretations. Many prisoners with Bailey claims, however, had already exhausted their first Section 2255 motion, and Bailey's statutory holding plainly did not satisfy either of Section 2255H's conditions for a second or successive motion. Several courts of appeals found a workaround for those prisoners in the Saving Clause. With minor differences in reasoning and wording, they held that Section 2255 was inadequate and ineffective under the Saving Clause, and that Section 2241 was therefore available when AEDPA's second or successive restrictions barred a prisoner from seeking relief, based on a newly adopted narrowing interpretation of a criminal statute that circuit precedent had foreclosed at the time of the prisoner's trial, appeal, and first Section 2255 motion. This application of the Saving Clause took shape in re Dorsonville, Treisman v. United States, and in re Davenport, and it was later adopted by most of the other circuits. We now hold that the Saving Clause does not authorize such an end run around AEDPA. In Section 2255H, Congress enumerated two, and only two, conditions in which a second or successive Section 2255 motion may proceed. Because Section 2255 is the ordinary vehicle for a collateral attack on a federal sentence, the straightforward, negative inference from Section 2255H is that a second or successive collateral attack on a federal sentence is not authorized unless one of those two conditions is satisfied. Even more directly, Section 2255H, 2's authorization of a successive collateral attack based on new rules of constitutional law implies that Congress did not authorize successive collateral attacks based on new rules of non-constitutional law. Had Congress wished to omit the word constitutional, it easily could have done so. The saving clause does not undermine this strong negative inference. Basic principles of statutory interpretation require that we construe the saving clause and Section 2255H in harmony, not set them at cross purposes. That task is not difficult given the distinct concerns of the two provisions. Subsection H presumes, as part of its background, that federal prisoners' collateral attacks on their sentences are governed by Section 2255, and it proceeds to specify when a second or successive collateral attack is permitted. The saving clause has nothing to say about that question. Rather, like subsection E, generally, it addresses the antecedent question of the relationship between Sections 2241 and 2255. After AEDPA, as before it, the saving clause preserves recourse to Section 2241 in cases where unusual circumstances make it impossible or impracticable to seek relief in the sentencing court, as well as for challenges to detention other than collateral attacks on a sentence. Because AEDPA did not alter the text of Section 2255E, there is little reason to think that it altered the pre-existing division of labor between Sections 2241 and 2255. AEDPA's new restrictions on Section 2255, therefore, are best understood as just that, restrictions on Section 2255, not as expansions of Section 2241's applicability. Any other reading would make AEDPA curiously self-defeating. It would mean that, by expressly excluding second or successive Section 2255 motions based on non-constitutional legal developments, Congress accomplished nothing in terms of actually limiting such claims. Instead, it would have merely rerouted them from one remedial vehicle and venue to another. Stranger still, Congress would have provided a superior remedy for the very non-constitutional claims it chose not to include in Section 2255H. After escaping Section 2255 through the saving clause, non-constitutional claims would no longer be subject to AEDPA's other express procedural restrictions, the one-year limitations period, and the requirement that a prisoner obtain a certificate of appealability before appealing an adverse decision in the district court. We generally resist attributing to Congress an intention to render a statute so internally inconsistent. That resistance is particularly acute here, where allowing non-constitutional claims to proceed under Section 2241 would mean resurrecting the very problems Section 2255 was supposed to put to rest. Section 2255 owes its existence to Congress' pragmatic judgment that the sentencing court, not the district court for the district of confinement, is the best venue for a federal prisoner's collateral attack on his sentence. Channeling a particular class of second or successive attacks back into Section 2241 would mean once again concentrating an inordinate number of habeas corpus actions in districts with large prison populations and requiring district courts to review each other's proceedings, often without access to the witnesses, the sources of evidence, or other local information that may be critical. The illogical results of applying such an interpretation argue strongly against the conclusion that Congress intended these results. Here, as often is the case, the best interpretation is the straightforward one. Section 2255H specifies the two limited conditions in which Congress has permitted federal prisoners to bring second or successive collateral attacks on their sentences. The inability of a prisoner with a statutory claim to satisfy those conditions does not mean that he can bring his claim in a habeas petition under the saving clause. It means that he cannot bring it at all. Congress has chosen finality over error correction in his case. Resisting this reading, Jones and the United States both argue that Section 2255H's exclusion of statutory claims sometimes renders Section 2255 inadequate or ineffective, though they advance different theories of when and why it does so. Their arguments are unpersuasive. Jones begins with a textual interpretation of the saving clause that, if accepted, would convert Section 2255E into a license for unbounded error correction. He argues that Section 2255 is necessarily inadequate or ineffective to test a prisoner's claim if the Section 2255 court fails to apply the correct substantive law. This argument ignores that the saving clause is concerned with the adequacy or effectiveness of the remedial vehicle, the remedy by motion, not any court's asserted errors of law. Even when circuit law is inadequate or deficient because a court of appeals precedents have resolved a legal issue incorrectly, that is not a fault in the Section 2255 remedial vehicle itself. Next, Jones offers a wide-ranging discussion of the concept of inadequacy as a term of art in traditional equity jurisprudence. While Jones demonstrates that courts of equity would afford relief from inadequate legal remedies in a broad range of circumstances, we find this excursus irrelevant to the question presented here. To the extent that Congress' use of inadequate in the saving clause harkens back to equity's historic use of that term, an issue we need not address, the most Jones's evidence proves is that a variety of circumstances might make it impracticable for a prisoner to seek relief from the sentencing court. Nothing in Jones's survey of equity jurisprudence, however, even begins to suggest that the saving clause offers an exemption from AEDPA's clear limits on second or successive collateral attacks. Trying a different tack, Jones suggests that the saving clause's use of the present tense is inadequate or ineffective, means that Section 2241 is available whenever a prisoner is presently unable to file a Section 2255 motion. Even the circuits with an expansive view of the saving clause have uniformly rejected this argument, and for good reason. Were this argument accepted, AEDPA's changes to Section 2255 would be entirely futile, as Section 2241 would be available any time the second or successive restrictions precluded relief. We decline to infer that Congress intended AEDPA's carefully crafted limits on collateral relief under Section 2255 to be mere nullities. As a backstop to his scattershot textual arguments, Jones invokes the constitutional doubt canon, arguing that denying him the chance to raise his rehaif claim in a Section 2241 petition raises serious constitutional questions. It does not. Jones's primary constitutional argument is that denying him any opportunity to seek post-conviction relief based on rehaif would violate the suspension clause, which provides that the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. This suspension clause argument fails, because it would extend the writ of habeas corpus far beyond its scope when the Constitution was drafted and ratified. When the suspension clause was adopted, and for a long time afterward, Jones's rehaif claim would not have been cognizable in habeas at all. At the founding, a sentence after conviction by a court of competent jurisdiction was in itself sufficient cause for a prisoner's continued detention. As Chief Justice Marshall explained in the seminal case of Ex parte Watkins, the criminal judgment, in its nature, concluded the subject on which it was rendered, pronounced the law of the case, and put an end to the inquiry concerning fact. Of particular relevance here, a habeas court had no power to look beyond the judgment to re-examine the charges on which it was rendered for substantive errors of law, even if the sentencing court had misconstrued the law and had pronounced an offense to be punishable criminally, which was not so. In rebuttal, Jones argues that pre-founding practice did allow habeas courts to look beyond the judgment to ensure that the convicting court had proved every element of the crime for which a prisoner was committed. But Jones fails to identify a single clear case of habeas being used to relitigate a conviction after trial by a court of general criminal jurisdiction. Rather, the cases he cites mostly involve commitments by justices of the peace, a distinction reflected in Watkins itself. At common law, justices of the peace were not courts of record, and did not possess general criminal jurisdiction. As such, their commitments were not placed on the same high ground with the judgments of a court of record. And the fact that superior courts sometimes used habeas to examine commitments by such inferior magistrates furnishes no authority for inquiring into the judgments of a court of general criminal jurisdiction. Jones also appeals to Bushell's case, which has long been understood as a case about the independence of criminal juries in determining questions of fact. There, a judge fined and imprisoned the members of a jury for acquitting William Penn and William Meade on indictments for assembling unlawfully and tumultuously, a verdict ostensibly against the manifest evidence. A juror refused to pay the fine, applied to the Court of Common Pleas for a writ of habeas corpus, and obtained discharge in an opinion by Chief Justice Vaughan. Jones points to one part of Vaughan's opinion, which criticized the return of the writ for not specifying that the jurors knew and believed the evidence to be full and manifest against the indicted persons, without which the juror's verdict was no cause of fine or imprisonment. Jones asks us to read this passage as reflecting a supposed common law rule that habeas relief was available whenever a convicting court had not found the necessary mens rea of a crime. That reading, however, entirely misses the actual basis of Vaughan's opinion, which was the judge's absolute want of power to question the jury's determination of the facts. Thus, Bushell's case no more undermines Watkins than do the justice of the peace cases. The principles of Watkins guided this court's understanding of the habeas writ throughout the 19th century and well into the 20th. Even in Ex parte Siebold, which held that the constitutionality of a prisoner's statute of conviction could be reviewed on habeas, as going to jurisdiction, the court acknowledged Watkins, and took pains to reconcile its holding with the traditional rule. And, when asked to review convicting courts' substantive errors of statutory law in habeas corpus proceedings, this court consistently held that it could not do so. It was not until 1974, in Davis, that the court broke with that tradition, holding for the first time that a substantive error of statutory law could be a cognizable ground for a collateral attack on a federal court's criminal judgment. The suspension clause does not constitutionalize that innovation of nearly 2 centuries later, nor, a fortiori, does it require the extension of that innovation to a second or successive collateral attack. Jones' remaining constitutional arguments are no more persuasive. He argues that denying him a new opportunity for collateral review of his rehive claim threatens separation of powers principles, specifically, Congress' exclusive power to define crimes, but the authority to determine the facts and the law in an individual case, and to render a final, binding judgment based on those determinations, stands at the core of the judicial power. A court does not usurp legislative power simply by misinterpreting the law in a given case. Next, Jones points to Fiore v. White, which applied the rule that due process requires that the prosecution prove every element of a crime beyond a reasonable doubt. Whether a due process error has occurred at trial, however, is an entirely different issue from Congress' power to restrict collateral review. Due process does not guarantee a direct appeal, let alone the opportunity to have legal issues redetermined in successive collateral attacks on a final sentence. Jones's last constitutional contention, that the Eighth Amendment's prohibition on cruel and unusual punishments may entitle him to another round of collateral review, fails for a similar reason. By its terms, the Cruel and Unusual Punishments Clause expresses a substantive constraint on the kinds of punishments governments may inflict. It creates no freestanding entitlement to a second or successive round of post-conviction review, and thus it adds nothing to Jones's unavailing suspension clause argument. The government agrees with the Eighth Circuit that Jones is not entitled to relief, but, somewhat surprisingly, it asks us to adopt a novel, alternative interpretation of the saving clause, which it constructs via a roundabout argument. It begins with the premise that the words inadequate or ineffective imply reference to a benchmark of adequacy and effectiveness. It proceeds to identify that benchmark as the ability to test the types of claims cognizable under the general habeas statutes, specifically, those governing federal habeas petitions by state prisoners. The government then reasons that Section 2255H's limitations, second or successive motions asserting newly discovered evidence or new rules of constitutional law, do not trigger the saving clause, because Congress has imposed analogous limitations on analogous claims by state prisoners and, by doing so, has redefined Section 2255E's implicit habeas benchmark with respect to such factual and constitutional claims. Since, the government asserts, Congress has imposed no analogous limitation on statutory claims by state prisoners, it has not redefined the implicit habeas benchmark with respect to statutory claims like Jones's, and we should be unwilling to infer that AEDPA limited such claims without a clearer textual indication. The government concludes that Section 2255H renders Section 2255 inadequate or ineffective. To test a federal prisoner's statutory claim in cases where the prisoner has already filed one Section 2255 motion, and the claim otherwise satisfies pre-AEDPA habeas principles, which generally will require a colorable showing of factual innocence. This elaborate theory is no more convincing than Jones's arguments. Its most striking flaw is the seemingly arbitrary linkage it posits between the saving clause and state prisoners' statutory post-conviction remedies. While it is true that Section 2255, as enacted, afforded the same rights federal prisoners previously enjoyed under the general habeas statutes, nothing in Section 2255's text, structure, or history suggests that Congress intended any part of it to implicitly cross-reference whatever modifications to state prisoners' post-conviction remedies might be made in the future. Understanding the saving clause to do so would have highly counterintuitive implications. On the government's view, Sections 2255H1 and H2 do not create an adequacy or effectiveness problem only because of the parallel state prisoner provisions in Section 2244B. It seems to follow that if Congress relaxed Section 2244B's second or successive restrictions for state prisoners tomorrow, and did nothing else, Section 2255 would suddenly become inadequate or ineffective to test at least some second or successive fact-based claims that did not satisfy Section 2255H1, or constitutional claims that did not satisfy Section 2255H2. and that those claims would then be allowed to proceed under Section 2241. We see no indication that the spare language of the saving clause creates such a Rube Goldberg contrivance, whereby changes to other statutory provisions, which do not apply to federal prisoners at all, could flow back into Section 2255 and undermine Section 2255H. In any event, as the government acknowledges, a state prisoner could never bring a pure statutory error claim in federal habeas, because federal habeas corpus relief does not lie for errors of state law. As a result, it is unclear what work the government's state prisoner habeas benchmark is even doing in its answer to the question presented here. Rather, the narrow base on which the government's top-heavy theory ultimately turns out to rest is its assertion that Section 2255H is simply not clear enough to support the inference that Congress entirely closed the door on pure statutory claims not brought in a federal prisoner's initial Section 2255 motion. That assertion is unpersuasive for the reasons we have already explained. Section 2255H specifies the two circumstances in which a second or successive collateral attack on a federal sentence is available, and those circumstances do not include an intervening change in statutory interpretation. The government asserts that we require the clearest command before construing EDA to close the courthouse doors on a strong equitable claim for relief. The only two cases the government relies on for its clear statement rule do not sweep as broadly as it suggests. In one case, we applied the general presumption of equitable tolling to a DSA one-year statute of limitations for state prisoners' habeas claims. Afterward, in another case, we held that a convincing showing of actual innocence could enable a prisoner to evade AEDPA's statute of limitations entirely. Undoubtedly, this assertion of equitable authority to override clear statutory text was a bold one. But even taking these cases for all they are worth, there is a significant difference between reading equitable exceptions into a statute of limitations, on the one hand, and demanding a clear statement before foreclosing workarounds to AEDPA second or successive restrictions, on the other. Statutes of limitations merely govern the time frame for bringing a claim. AEDPA's second or successive restrictions, by contrast, constitute a modified res judicata rule, and thus embody Congress' judgment regarding the central policy question of post-conviction remedies, the appropriate balance between finality and error correction. Insisting on a heightened standard of clarity in this context would effectively mean adopting a presumption against finality as a substantive value. We decline to do so. The United States has an interest in the finality of sentences imposed by its own courts, and how to balance that interest against error correction is a judgment about the proper scope of the writ that is normally for Congress to make. Accepting the government's proposal to apply a clear statement rule would be particularly anomalous in light of the precise question this case presents. Typically, we find clear statement rules appropriate when a statute implicates historically or constitutionally grounded norms that we would not expect Congress to unsettle lightly. But, as shown above in discussing Jones's suspension clause argument, there is no historical or constitutional norm of permitting one convicted of a crime by a court of competent jurisdiction to collaterally attack his sentence based on an alleged error of substantive statutory law. As far as history and the Constitution are concerned, there is nothing incongruous about a system in which this kind of error, the application of a since-rejected statutory interpretation, cannot be remedied after final judgment. A fortiori, there is nothing fundamentally surprising about Congress declining to make such errors remediable in a second or successive collateral attack. We affirm the judgment of the Court of Appeals. It is so ordered. Justice Sotomayor and Justice Kagan, dissenting. We respectfully dissent. As Justice Jackson explains, today's decision yields disturbing results. A prisoner who is actually innocent, imprisoned for conduct that Congress did not criminalize, is forever barred by Section 2255H from raising that claim, merely because he previously sought post-conviction relief. It does not matter that an intervening decision of this court confirms his innocence. By challenging his conviction once before, he forfeited his freedom. Though we agree with Justice Jackson that this is not the scheme Congress designed, we see the matter as the Solicitor General does. As all agree, Congress enacted Section 2255 to afford federal prisoners a remedy identical in scope to federal habeas corpus. To ensure that equivalence, Congress built in a saving clause, allowing recourse to habeas when the remedy by motion under Section 2255 is inadequate or ineffective compared to the remedy it replaced, an application for a writ of habeas corpus. So, as this court has explained, if Section 2255 bars a claim cognizable at habeas, such that the remedies are not commensurate, the saving clause kicks in, and the prisoner may proceed in federal habeas corpus. With that understanding in mind, consider a prisoner who, having already filed a motion for post-conviction relief, discovers that a new decision of this court establishes that his statute of conviction did not cover his conduct. He is out of luck under Section 2255, because Section 2255H will bar his claim. But that claim is cognizable at habeas. where we have long held that federal prisoners can collaterally attack their convictions in successive petitions if they can make a colorable showing that they are innocent under an intervening decision of statutory construction. Congress did not abrogate that principle in Section 2255H. Thus, we have precisely the kind of mismatch the saving clause was designed to address. In this case, the petitioner says he is that prisoner with that mismatch, but the Court of Appeals never considered that question, laboring under a mistaken view of the saving clause that, like the majority's, assigns it almost no role. Accordingly, we would remand for the lower courts to consider the petitioner's claim under the proper framework. Justice Jackson, dissenting. Today, the court holds that an incarcerated individual who has already filed one post-conviction petition cannot file another one to assert a previously unavailable claim of statutory innocence. The majority says that result follows from a straightforward reading of the law, but the majority reaches this preclusion decision by negative inference. It is far from obvious that the bar on filing second or successive post-conviction petitions, with certain notable exceptions, prevents a prisoner who has previously sought post-conviction relief from bringing a newly available legal innocence claim in court. In any event, putting aside its questionable interpretation of the law, the majority is also wrong to interpret the saving clause as if Congress designed that provision to filter potential habeas claims through the narrowest of apertures, saving essentially only those that a court literally would be unable to consider due to something akin to a natural calamity. This stingy characterization does not reflect a primary aim of the saving clause, which was to save any claim that was available prior to the enactment of the bar on successive petitions where Congress has not expressed a clear intent to foreclose it. Jones's legal innocence claim fits that mold. I am also deeply troubled by the constitutional implications of the nothing-to-see-here approach that the majority takes with respect to the incarceration of potential legal innocence. Apparently, legally innocent or not, Jones must just carry on in prison regardless, since no path exists for him to ask a federal judge to consider his innocence assertion, but forever slamming the courtroom doors to a possibly innocent person who has never had a meaningful opportunity to get a new and retroactively applicable claim for release reviewed on the merits raises serious constitutional concerns. Thus, in my view, all roads lead to an interpretation of the law that is diametrically opposed to the one that the majority announces. Whether one gets there by virtue of a proper reading of the saving clause, or an informed understanding of the bar on successive petitions, or by affording due respect to the core constitutional interests at stake, Jones's successive petition alleging legal innocence should have been considered on the merits. Therefore, I respectfully dissent. Section 2255E saves post-conviction claims by authorizing the filing of a habeas petition if the procedures afforded are inadequate or ineffective to test the legality of a prisoner's detention. I sig? No reason why the only circumstance in which the procedures qualify as inadequate or ineffective for saving clause purposes is when it is impossible or impractical for a prisoner to file a motion. Quite to the contrary, the enactment history of Section 2255 plainly establishes that Congress wanted to ensure that a prisoner's claim was saved in at least one additional set of circumstances, where the prisoner would have been able to bring such a claim prior to the enactment of Section 2255, or any subsequent changes, but somehow cannot bring that claim after a change to the statutory framework, unless Congress has clearly expressed its intent to restrict the scope of relief in that regard. As the majority has interpreted the law, that is precisely the situation here. To understand why Congress meant for Jones to be able to invoke the saving clause and bring his statutory innocence claim in a habeas petition filed under Section 2241, a firm grasp of the text, history, and intended operation of Section 2255E is required. The saving clause is the latter part of Section 2255E, which states in full, an application for a writ of habeas corpus on behalf of a prisoner who is authorized to apply for relief by motion pursuant to this section shall not be entertained if it appears that the applicant has failed to apply for relief, by motion, to the court which sentenced him, or that such court has denied him relief, unless it also appears that the remedy by motion is inadequate or ineffective to test the legality of his detention. Before Section 2255 was enacted in 1948, federal prisoners collaterally attacked their convictions by filing a habeas petition. Such petitions sought judicial review of the legality of the individual's detention, and were filed in the district where the person was incarcerated. This led to some problems. Districts that housed large federal prisons were disproportionately burdened with habeas petitions. Also, in many cases, the court deciding the petition was both unfamiliar with the underlying facts and far away from the relevant record, evidence, and witnesses. Congress created Section 2255, an entirely new process for federal prisoners to use when seeking post-conviction judicial review, to solve these practical problems. Under the procedures laid out in Section 2255, in lieu of filing a traditional habeas petition, federal prisoners must file a Section 2255 motion, and any such motion is to be filed in the sentencing court, not in the district of confinement. Congress crafted what is now Section 2255E, to ensure that the new Section 2255 procedure successfully ousted the outdated habeas regime it replaced. Per the first part of that provision, as a general matter, Section 2255 becomes the exclusive procedure by which federal prisoners can collaterally attack their convictions. Yet Congress also specified that, in a circumstance in which Section 2255 is inadequate or ineffective to test the legality of his detention, an individual could still file a habeas petition. There are multiple ways in which Section 2255 might be insufficient or not capable of performing the required work of post-conviction review of federal convictions. For example, Section 2255 would not be up to the task if it would be impossible or impracticable for a federal prisoner to file a Section 2255 petition. The case before us involves another way that Section 2255 can be inadequate or ineffective, where the newly created Section 2255 procedure, perhaps inadvertently, blocks a prisoner from bringing a claim that was previously cognizable in habeas. This is an inadequacy concerning the operation of Section 2255 from Congress's perspective, because the sole purpose of Section 2255 was to minimize the difficulties encountered in habeas corpus hearings, while still affording the same rights in another and more convenient forum. That much is not in dispute. The majority acknowledges that Congress intended to maintain equivalence with the claims available in habeas when it enacted Section 2255. Consequently, in any circumstance in which the new Section 2255 procedure actually operates to foreclose a post-conviction claim that a prisoner could have brought previously in a habeas petition, the Section 2255 process is patently inadequate to accomplish Congress's aim of allowing prisoners to test the legality of their detention under Section 2255 to the same extent as they could have in the habeas regime that Section 2255 replaced. Thus, the saving clause can be properly interpreted as effectuating Congress's intent in this regard. As the government persuasively argues, by inserting a provision that allows prisoners to still file habeas petitions, Congress ensured that Section 2255 does not disadvantage federal prisoners as compared to habeas. That is, where a federal prisoner could have brought a particular habeas claim prior to 1948, but could not bring such a claim in a Section 2255 petition after that date, the saving clause kicks in to permit that individual to resort to habeas to raise that claim. This reading of Section 2255E means that the saving clause operates, at the very least, and as it was enacted in 1948, preserve from inadvertent extinguishment post-conviction claims that would have been previously cognizable for federal prisoners, but cannot be brought by operation of Section 2255. And the flip side of that interpretation? That Section 2255 is inadequate or ineffective if it sub silentio extinguishes previously available habeas claims, triggering the saving clause, inexorably follows. This interpretation tracks Congress's clear claim preservation goal. And, as an added bonus, it also has the benefit of being in accordance with how saving clauses usually work. Fast forward to 1996, Congress reenacted the saving clause, using identical language, when it passed EDA. Thus, because the saving clause operated in 1948 to save from inadvertent extinguishment habeas claims that were available before the enactment of Section 2255, the same was true when Congress revised those procedures in the mid-1990s, while keeping the saving clause intact. In other words, both in 1948 and to this day, the saving clause operates to, among other things, ensure that Section 2255, or the AEDPA amendments, did not, through inapt language, substantively alter the scope of available post-conviction relief for federal prisoners. This is not to say that Congress necessarily carried forward all of its previous policy determinations with respect to the availability of post-conviction claims, or that it did not change its mind at all about the appropriate dimensions of post-conviction relief. Indeed, habeas is a dynamic remedy, and congressional enactments contribute to its evolution. But, again, the saving clause, which served an important equalizing function, remained intact when Congress reenacted Section 2255 in 1996. Thus, while Congress can certainly act to change the scope of habeas or its statutory equivalent if it wants to do so, in order to overcome the operation of the saving clause, which, again, was inserted to maintain equivalence in the absence of intent to make a change, Congress has to make said change to the availability of post-conviction relief deliberately and clearly, thereby unequivocally expressing its intent to do so. All this means that today, as in 1948, the saving clause is best interpreted as allowing for the filing of a habeas petition under Section 2240, one where a claim that was cognizable prior to EDA cannot be brought under Section 2255, unless Congress has clearly expressed its intent to foreclose that particular claim. That brings us to the situation at issue here. When Congress amended Section 2255 by enacting AEDPA, it legislated against a legal background in which a federal prisoner could bring a statutory innocence claim in a Section 2255 petition. The majority does not dispute this, nor could it, because this court made crystal clear in 1974 in Davis that statutory innocence claims are legally cognizable in a Section 2255 motion. Moreover, prior to AEDPA's enactment, a federal prisoner could bring such a post-conviction claim of statutory innocence in a successive petition. This court had generally restricted successive post-conviction filings by the 1990s, but a prisoner who had previously filed at least one petition could still file another one in order to assert innocence. That was because any bar to the filing of a successive petition was typically lifted if enforcing that bar would result in a miscarriage of justice. And under our settled precedent, legal innocence claims fit that category. These background principles relate to the successive petition that Jones seeks to bring here as follows. If the majority is right that, by virtue of Section 2255H, prisoners like Jones are now unable to bring a successive Section 2255 petition to make the same kind of legal innocence claim that they could have brought prior to AEDPA, then Congress's enactment of Section 2255H has dramatically altered the legal landscape in a manner that seems, at best, inconsistent with its original intent. To repeat, the Saving Clause expresses a congressional intent to maintain equivalence between what a prisoner could claim before and after Section 2255H, yet under the majority's reading, Section 2255H's second or successive bar would effectively operate to preclude successive legal innocence claims, shrinking the universe of previously available claims, the opposite of what Congress set out to do when it set up Section 2255. In my view, that is where the Saving Clause comes in. Reading the Saving Clause to perform its normal, intended function of saving previously available claims solves this problem, because it allows prisoners who could have brought a claim prior to the enactment of AEDPA, like Jones, to file a habeas petition to the extent that Section 2255 now precludes such a filing under that particular statutory mechanism, thus interpreting Section 2255E's inadequate and ineffective language to permit the filing of a habeas petition that raises a legal innocence claim in these circumstances seems perfectly consistent with Congress's intent. This understanding of the Saving Clause also explains the clause's application, or, more precisely, its inapplicability, to the types of claims specifically mentioned in Sections 2255, H, 1, and 2. Congress has expressly overridden operation of the Saving Clause with respect to those two provisions, because it has clearly expressed its intent to narrow the scope of post-conviction relief where a federal prisoner brings a successive petition raising a claim of new evidence or new constitutional law. And here, no one questions that. With Sections 2255H, 1, and 2, Congress clearly did so. But the majority now reasons that, merely by omitting statutory innocence claims from that authorized filings list, Congress should be deemed to have exhibited a narrowing intent with respect to those claims as well. I disagree. Indeed, in my view, it is precisely because the text of Sections 2255H, 1, and 2 speaks unequivocally to the narrowing Congress wished to effect with respect to new evidence and new constitutional claims that we should not ascertain that Congress meant for the second or successive bar to have the same effect with respect to legal innocence claims, which, importantly, the statute does not mention. To put it bluntly, Congress knows how to speak clearly when it wants to disrupt the continuity of claims that are available to prisoners before and after it enacts legislation that addresses post-conviction review procedures. And rather than providing any such clear statement as to how an intervening claim of statutory innocence should be treated, vis-a-vis Section 2255H's second or successive bar, Congress was conspicuously silent. The majority advances an entirely different theory of the work that Section 2255E does with respect to the post-conviction review scheme, a theory that I do not find even remotely persuasive. Opting for the narrowest possible view of Congress's intent regarding the Saving Clause, the majority generally claims that the Saving Clause only authorizes the filing of a habeas petition if filing a Section 2255 motion would be impossible or impracticable. And in the majority's telling, that circumstance only occurs, say, if the courthouse where a Section 2255 motion would have otherwise been filed has burned to the ground or been carried away by a mudslide. The majority's parsimonious perspective on the meaning of inadequate or ineffective is flawed in many respects. First and foremost, it is entirely atextual. The majority cites exactly 0 dictionary definitions of the terms inadequate or ineffective. Furthermore, While the majority opinion accurately recites the history and purpose of Section 2255, it ignores the import of that history. As explained above, when Congress enacted Section 2255 in 1948, it intended to ensure equivalence between traditional habeas and the new Section 2255 mechanism for post-conviction review. Accordingly, Congress inserted the saving clause to ensure that certain pre-existing post-conviction claims, say, a claim of statutory innocence, could still be heard even if the statutory language Congress was adopting inadvertently barred them. And Congress preserved the language of Section 2255E, the language that performs the equalizing function. In 1996, even as it made other significant changes to Section 2255. Ignoring all this, the majority grounds its analysis of Section 2255E in a scattershot of lower court cases that the majority claims traditionally viewed the saving clause as solving only for practical filing problems. To be sure, a handful of lower courts applied the saving clause where the sentencing court was dissolved. Verk? Lower courts have also traditionally treated the saving clause as permitting individuals with previously unavailable statutory innocence claims to file habeas petitions in light of Section 2255H's successive petition bar. The majority also fails to grapple with this court's own opinions that suggest a broader interpretation of the saving clause is proper. It appears the majority's interpretation of Section 2255E is primarily attributable to its concern that interpreting the saving clause to permit Jones to file a habeas petition might authorize an end run around Section 2255's procedures. I think those fears are vastly overblown. Properly interpreted, a Section 2255 motion is only inadequate or ineffective when the potential procedural bar does not provide a prisoner with any meaningful opportunity to present a claim, and that circumstance does not exist any time a procedural limitation in Section 2255 screens out a claim. For example, if an individual does not raise his legal innocence claim in a Section 2255 motion in a timely fashion, he cannot resort to the saving clause to file a habeas petition. That individual did have a meaningful opportunity to raise his claim pursuant to the Section 2255 process, but missed the window of opportunity. Similarly, where Congress has clearly narrowed the scope of post-conviction relief, as it has done for claims of new evidence and new constitutional rules, it has overridden the equivalence aim that would otherwise render Section 2255 inadequate or ineffective, such that the saving clause does not apply. On top of this, given the congruence purpose underlying Section 2255E, an individual can resort to habeas via Section 2255E only, where the particular claim he seeks to bring would have been cognizable under pre-AEDPA principles. Thus, the majority has no good answer to interpreting the saving clause as doing what Congress crafted it to do. Among other things, ensuring equivalence between Section 2255 and the prior post-conviction remedy being replaced or modified, unless Congress clearly establishes otherwise. A successive statutory innocence claim could have been brought prior to the 1996 edition of Section 2255H, and Congress has not clearly foreclosed such claims in the text of Section 2255. Therefore, the saving clause applies, and Jones should have been permitted to raise his legal innocence claim by filing a habeas petition under Section 2241. The foregoing analysis assumes, as the majority does, that the only hope of a prisoner in Jones's position is to assert his statutory innocence claim via a habeas petition filed under Section 2241 per the saving clause, because Section 2255H prevents the filing of such a successive Section 2255 motion. But I would not be so quick to assume that a successive Section 2255 motion asserting statutory innocence is impermissible due to Section 2255H. Here is why. Nothing in the whole of Section 2255 suggests that Congress ever considered the scenario presented in this case, one in which a prisoner who has already filed a post-conviction motion suddenly gets a new claim of legal innocence after his first petition was filed, based on a development in Supreme Court case law. Therefore, it is not at all clear that Congress determined that such an individual is simply out of luck. Far from making the decision that a prisoner in this circumstance should not be permitted to raise that newly available claim by filing another Section 2255 motion, as the majority maintains, Congress has simply never spoken to what is supposed to happen with newly available claims of legal innocence. To reach today's conclusion, then the majority draws a negative inference that Congress intended for Section 2255's second or successive bar to preclude successive filings that contain legal innocence claims. But the majority's inferential reasoning is highly problematic in at least two respects. First, negative inferences drawn without proper context can be notoriously unreliable. And, as detailed below, there are myriad reasons for skepticism here. Section 2255H's anti-claim splitting purpose is one. Another is the likely reason that legal innocence claims do not appear in the text of the statute. Spoiler alert. They were inadvertently omitted. Background equitable principles and the practical consequences of preventing the filing of successive petitions in this circumstance are additional key contextual clues that the majority seems to have missed. Second, I am suspicious of the majority's choice to resort to inferential reasoning at all. Given that this court has long held that we will not read a statute to displace access to the Great Writ, unless Congress has been clear about its intention to accomplish this result, the clear statement rule is plainly applicable here, and the majority offers the flimsiest of explanations for its decision to deviate from its application at the threshold of today's interpretation. In short, as shown below, the initial assumption that Congress necessarily meant for Section 2255H to bar Jones's successive petition asserting statutory innocence is shaky, at best. I would have held that Jones's petition can proceed, even without reliance on the saving clause, because Section 2255H does not bar it. The majority says that since AEDPA second or successive Section 2255 motions are barred unless they rely on one of two, and only two, circumstances, newly discovered evidence, Section 2255H(1), or a new rule of constitutional law, Section 2255H(2), legal innocence claims are barred, the majority holds, pursuant to this straightforward negative inference. But there is a good reason that the negative inference canon must be applied with great caution, and the reason is that its application depends so much on context. In this case, for instance, there are several strong contextual clues that substantially undercut the majority's purportedly straightforward inferential reasoning. First of all, while the majority interprets Section 2255H as if Congress designed that provision to impose finality without regard to the claims at issue, other than the two listed situations, as it turns out, that is not the primary purpose of Section 2255H. Instead, Section 2255H's second or successive petition bar was inserted into EDA to ensure that all available claims a prisoner has are brought in a single post-conviction petition. In circumstances where the prisoner seeks to assert a claim that was previously unavailable, i.e., a claim that could not have been raised before, Congress permitted successive petitions. Explaining this fully requires me to make a preliminary big-picture point. Section 2255, originally, and as amended by AEDPA, is not a gauntlet of arbitrary hurdles that Congress has erected to stymie prisoners who seek to obtain judicial review of their detention. Indeed, as explained, when Congress first enacted Section 2255, it had no intention of shrinking the catalog of available post-conviction claims. To be sure, Congress has undertaken to restrict the writ's availability somewhat since Section 2255 was first enacted, but it has nevertheless continued to appreciate the significance of access to post-conviction review of the legality of a prisoner's detention. Hence, even after AEDPA, Congress permits all incarcerated individuals, including those who have been convicted of serious crimes, and who are serving sentences that have been imposed by courts of competent jurisdiction, to seek collateral relief. Still, when it enacted ETA in 1996, Congress was aware of how Section 2255's post-conviction processes had been operating on the ground since Section 2255's enactment. Thus, Congress quite rationally sought to balance the individual interest in justice that arises in the extraordinary case with the societal interest in finality, comity, and conservation of scarce judicial resources. Section 2255H reflects this balancing. What emerges from a review of the debates over the successive petition restrictions is a clear sense that Congress wanted to prevent manipulation of the system through relitigation of previously presented claims or strategic withholding of claims for later presentation, while still creating a mechanism that would allow prisoners to have one full, fair chance to present their meritorious claims to the federal courts. As Senator Hatch said at the time, "We have provided for protection of federal habeas corpus, but we do it one time and that is it, unless, of course, they can truly come up with evidence of innocence that could not have been presented at trial. There we allow successive petitions." Then Senator Biden similarly explained that the goal of AEDPA was essentially giving one bite out of the apple to drastically reduce the ability to have successive petitions, unless there is some egregious action that is learned about after the petition is filed, the first petition. Thus, Congress enacted Section 2255H to prevent prisoners from engaging in manipulative filing practices, such as claim splitting, i.e., the inefficient business of prisoners with time on their hands doling out their existing post-conviction claims in a series of successive motions filed in court seriatim. And, tellingly, because Congress was focused on that problem, not attempting to impose finality writ large, it did not bar all successive petitions. To the contrary, it proceeded to identify particular circumstances in which another collateral challenge would be authorized. Additional doubts about the majority's negative inference surface when one recognizes that the two circumstances Congress carved out of the successive petition bar share an important common thread. Both situations relate to the newness of the claim that the prisoner seeks to assert in a successive petition. That is, both prongs of Section 2255H that authorize a successive petition do so where a petitioner brings a claim that arose after the time in which the prisoner would or could have filed his first petition. Authorizing successive petitions raising newly discovered evidence or a new rule of constitutional law, emphasis added. In light of this key observation, the majority's assumption that Section 2255H bars Jones's claim is significantly hobbled. Jones's statutory innocence claim is also new in the sense that it was not available to him when his first Section 2255 petition was filed. And Jones's claim shares other features of the circumstances that Congress exempted from the second or successive general prohibition as well, including that it implicates innocence and stems from a retroactively applicable Supreme Court opinion. Nor does the filing of Jones's successive petition implicate any anti-claim splitting rationale, as Jones did not manipulatively withhold his legal innocence claim during his initial Section 2255 proceedings. Indeed, he could not possibly have done so, since this court did not decide Relied v. United States, which provided the basis for his claim, until nearly 2 decades after Jones filed his first petition. In short, it is hard to believe that a Congress that expressly authorized new claims involving innocence or those that arise from developments in Supreme Court case law despite Section 2255H's successive petition bar, also meant for Section 2255H, to preclude Jones from bringing the claim that he seeks to file here. The majority's negative inference also rests on the bald assumption that Congress intentionally left statutory innocence out of its list of carve-outs, because it wanted those claims to be barred if brought in a successive petition. But there is a perfectly logical alternative explanation for why statutory innocence claims do not appear as express exclusions in the text of Section 2255H, an explanation that is based on another important contextual reference point, the enactment history of the statute. Section 2255H was enacted in the same public law as Section 2244B, a provision that contains analogous second or successive petition limitations for state prisoners. Indeed, Congress appears to have modeled Section 2255H too on those state prisoner provisions. Like Section 2255H, Section 2244B, the model provision, does not address statutory innocence claims in any fashion, but that is simply because there is no such thing as a statutory innocence claim in the realm of federal collateral relief for state prisoners. Thus, as others have observed, when Congress crafted Section 2255H based on the state prisoner model in Section 2244B, it seems to have lost sight of the fact that federally incarcerated individuals can raise federal statutory claims in their collateral attacks. To me, this contextual revelation rocks the foundation of the majority's negative inference. That is, it is plausible, and perhaps even likely, that Congress did not appreciate fully that the modeled-after language establishing a successive petition bar did not capture the full scope of available claims for federal prisoners. And, of course, if Congress simply overlooked statutory innocence claims when it crafted Section 2255H, then the omitted language that the majority puts so much stock in is not actually indicative of Congress having chosen finality with respect to statutory innocence claims. Instead, the absence of any textual reference to statutory innocence would be wholly unremarkable. Given the purpose and history of Section 2255H as I have just described them, I find quite compelling the government's observation that nothing in AEDPA actually justifies an inference that Congress silently repealed the traditional post-conviction remedy for federal prisoners who have been imprisoned for conduct that Congress did not criminalize. I proceed here to add that nothing outside of AEDPA, not the background legal principles that existed at the time Congress enacted the statute, nor the practical consequences of reading Section 2255H in this manner, supports that inference either. Take equity, for instance. When Congress crafted Section 2255H, it legislated against an important background equitable principle pertaining to post-conviction relief. Courts should not interpret statutory provisions governing habeas review to even run the risk of causing prisoners to forever lose their opportunity for any federal review of their claims. This means that Congress was well aware that courts consistently rely on equitable doctrines to carve out ways petitioners can bypass otherwise applicable procedural obstacles when a prisoner has not had a full and fair opportunity to litigate their federal claims. Knowing that courts are equitable tribunals that tend to operate in this fashion should have prompted Congress to express its intention to override that value, assuming that it actually intended to completely foreclose new legal innocence claims. Congress did not do so, yet the majority reads its silence to accomplish that same extraordinarily inequitable result. The practical consequences that inure from the majority's reading also undercut substantially the negative inference upon which the majority relies. We have consistently warned that courts should resist an interpretation of AEDPA that would produce troublesome results and create procedural anomalies. The majority does not speak to this at all. but its interpretation of Section 2255 produces bizarre outcomes. First, there is the quirky procedural anomaly that arises due to the fact that statutory innocence claims are fully authorized in the post-conviction review context. This court's recognition that a statute covers a narrower scope of criminal conduct than was previously acknowledged falls within the narrow subset of criminal law decisions that are fully retroactive, meaning that a federal prisoner can rely upon that new determination whether his case is still on direct review or not. But reading Section 2255H to bar a successive petition raising legal innocence would mean that most prisoners who would, remarkably, be eligible for such retroactive relief would turn out to have no mechanism for actually requesting it. A strange practical conundrum, to say the least. Inferring that Section 2255H bars legal innocence claims when brought in a successive petition also produces stunningly disparate results that bear no relationship to Congress's purported finality goals. Consider two individuals who have been convicted of the same federal crime, perhaps two co-defendants who were tried and sentenced together. Both complete their direct appeals, but only one files a Section 2255 motion within AEDPA's statute of limitations, while the other one decides not to or misses the deadline. If Section 2255H bars a successive petition raising a legal innocence claim, then when rehafe is handed down, altering the elements of the crime of conviction such that both prisoners have a colorable claim of legal innocence, only the one who did not previously file a Section 2255 petition can raise this retroactive statutory innocence claim. Reference to Congress's interest in finality cannot explain this odd, unequal treatment. Under the court's interpretation, a prisoner whose conviction became final 30 years ago can assert a rehafe claim if he never previously filed a Section 2255 motion, whereas someone whose conviction became final 2 years ago cannot, if he has already had a Section 2255 petition adjudicated. Interpreting Section 2255H as completely foreclosing successive petitions, bringing statutory innocence claims, also places prisoners in an untenable catch-22 that cannot be what any rational Congress actually intended. Consider what has happened in this very case. Per AEDPA's statute of limitations, Jones had to file his first Section 2255 petition within 1 year of his conviction becoming final. He did so, and that petition was successful. The Eighth Circuit found that Jones had received ineffective assistance of counsel. In the majority's view, by seeking to vindicate his Sixth Amendment rights in this way, Jones has forfeited, forever and for all time, his right to rely on any new retroactive Supreme Court opinion that suggests he is incarcerated for non-criminal behavior. There is no indication that Congress meant for Jones and other prisoners in his position to have to choose between pursuing an ineffective assistance of counsel claim and a claim of legal innocence. Despite all this, the majority clings to its straightforward negative inference, and interprets Section 2255H as a bar to a court's consideration of Jones's legal innocence claim. My point is that, with so many contextual indicators that Congress did not really mean for Section 2255H to be read to preclude new claims of statutory innocence, the court should have simply determined that Jones's petition, which asserts such a claim, was not plainly barred by Section 2255H, and could thus proceed in a successive Section 2255 petition. Instead of drawing an inference about the operation of Section 2255H, the most straightforward way of determining whether Jones's legal innocence claim is precluded by statute would have been to apply our clear statement rule to today's interpretation. A long-standing rule of this court, the clear statement rule directs that before interpreting a congressional enactment as closing the court's doors to a class of habeas petitioners, the court must search for a clear indication that such was Congress' intent. This principle recognizes that Congress must speak unambiguously when it seeks to effect a result that, although constitutional, would undermine a constitutionally derived value. And before today, court has repeatedly recognized the importance of the clear statement rule with respect to any analysis of an act of Congress that potentially restricts access to the writ of habeas corpus or its statutory equivalent. In fact, where a provision precluding review is claimed to bar habeas review, we have required a particularly clear statement. The clear statement rule is plainly implicated here. Under the state of the law at the time ETA was enacted, prisoners were entitled to bring a petition to assert a new claim of legal innocence, even a second or successive petition. Congress could change that state of affairs, but under the clear statement rule, if it intended to do so, it needed to speak clearly to effectuate that result. At a more general level of analysis, the clear statement rule also applies to these circumstances, because the interpretive question in this case touches upon the venerated writ of habeas corpus, the only writ that is expressly mentioned in the Constitution. We have long recognized that the clear statement rule serves the core liberty interests protected by the writ of habeas corpus. Likewise, in modern times, we have been especially careful to reference clear statement principles, and thereby eschew statutory interpretations that would, perhaps unintentionally, foreclose judicial review of post-conviction claims, even where the text of the statute might, sometimes even strongly, suggest otherwise. Furthermore, and significantly for present purposes, we have already determined that the necessary clear statement here, i.e., the signal from Congress that justifies reading a statute as foreclosing access to venerated post-conviction review processes, cannot be derived from negative inferences drawn from statutory text. In Ex parte Yerger, for instance, we declared that interpreting a statute to repeal by implication habeas jurisdiction is not favored. More recently, we warned, again, that implications from statutory text or legislative history are not sufficient to repeal habeas jurisdiction. Instead, Congress must articulate specific and unambiguous statutory directives to effect a repeal. And, again in Holland, this court explained that the clear statement rule generally prohibits a court from inferring that the inclusion of one item is to exclude other similar items in order to read a statute as forbidding review of a post-conviction claim. Yet here, as the majority appears to admit, the only way to read Section 2255H as barring Jones's statutory innocence claim is to infer that such preclusion is what Congress intended. This case would have been easily resolved if we had applied the clear statement rule at the outset, as we have always done in cases of this nature. Doing so would have appropriately eliminated a reading of Section 2255H that forecloses access to habeas relief by negative implication. Use of the rule would have thus protected core constitutional norms by ensuring Congress does not, by broad or general language, legislate on a sensitive topic inadvertently or without due deliberation. In the last few pages of its opinion, the court makes the unceremonious but still startling announcement that the clear statement rule is inapplicable to today's analysis of Section 2255H. Try as it might, in my view, the majority has failed to provide a single persuasive reason for this dramatic break. First, the majority suggests that the clear statement rule is not appropriate when interpreting provisions related to finality, and seems to draw a line between AEDPA's statute of limitations, which does get clear statement treatment, and its provisions governing successive petitions. This is nonsense. Both AEDPA provisions use similar language, and both procedural limitations relate to Congress's interest in finality. Next, the majority conspicuously downplays the stakes in this case. No once does its opinion make direct mention of the fact that the claim the majority says Section 2255H silently precludes is one that implicates core values because it involves legal innocence. Instead, the majority repeatedly describes Jones's bid for access to the post-conviction review process as bringing a mere statutory claim. But statutory claims that suggest a person's innocence are different in kind from more run-of-the-mill statutory claims, such as a technical, non-prejudicial violation of a criminal procedure rule. In any event, the majority does not cite a single case that suggests that an act of Congress that threatens to cut off access to habeas, or its statutory equivalent, should be treated any differently for purposes of application of the clear statement rule if a petitioner's claim has a statutory basis. The majority's most full-throated defense of its jettisoning of clear statement principles lies in its attempt to cast statutory innocence claims as not historically or constitutionally grounded. The first and most obvious problem with this effort is that the historical pedigree of a claim is irrelevant for clear statement purposes. The clear statement rule is applicable here because the statute being interpreted involves access to the writ of habeas corpus, a significant constitutional value that we would not assume Congress would discard without careful consideration. And, so triggered, our clear statement canon of construction is not rendered inapplicable just because the particular type of claim that a prisoner seeks to advance in the context of a habeas or post-conviction proceeding, if he is afforded one, might not date back to the founding era. This must be why the majority cites no precedent that splices the clear statement rule in this fashion. Looking back to the time of the founding to determine whether the clear statement rule applies to our interpretation of a statute passed in 1996 also makes no sense. The clear statement question relates to what Congress intended with respect to the meaning of the statute at the time it was enacted. When Congress introduced Section 2255H, it codified or changed the law that existed at that time, i.e., in 1996. Thus, when this court has previously applied the clear statement rule and analyzed the meaning of particular AEDPA provisions, the feelings of the framers were of no moment. Instead, we properly examined the law leading up to AEDPA's enactment, not founding-era sources. Even if the majority was right with respect to its assumption that founding-era practices bear on whether the clear statement rule applies here, historical practice plainly undermines its assertion that legal innocence claims are of recent vintage. Supreme Court justices riding circuit in the early 19th century repeatedly considered the merits of habeas petitions filed by individuals who argued they were being wrongfully incarcerated because the laws that had been invoked to justify their confinement, properly construed, did not reach their conduct. Moreover, and importantly, since the mid-19th century, the statutory scheme for post-conviction review has permitted petitions based not only on a violation of the Constitution, but also on a violation of the law of the United States. To the extent the majority's assessment of the purportedly nascent nature of statutory innocence claims rests on its view that, at the time of the founding, habeas relief was rarely available when a petition was brought by a convicted individual, as opposed to a pre-trial detainee, there are two additional problems. For one thing, even assuming that a detainee versus convict scope of habeas distinction existed at the dawn of our nation, Congress has now squarely rejected it. However grounded in history and tradition the court's own view of the scope of habeas might be, it is obviously not shared by the legislature that enacted the statute we are now interpreting. Second, here again, the majority evaluates the historical pedigree of legal innocence claims based on faulty history. It maintains that, historically, a court could review a habeas petition filed by a convicted individual only for jurisdictional errors, which the majority defines narrowly. But those who have researched this contention have called it narrative and myth but not history. At the very least, this take on early habeas practice appears contradicted by United States v. Bainbridge. There, Justice Story considered a statutory innocence claim on the merits even though the individual had already pleaded guilty. And the post-conviction/pre-conviction distinction also runs headlong into other precedents that have looked back on history and do not subscribe to such a narrow view. Thus, assuming, arguendo, that the historical grounding of the particular type of claim Jones sought to bring even matters, the majority is mistaken when it contends that a statutory innocence claim, including one brought in a successive petition, is not sufficiently historical to warrant application of our clear statement rule. If the majority had applied the clear statement rule, as it should have, to determine whether Section 2255H precludes successive post-conviction petitions that assert statutory innocence claims, today's interpretive task would have merely involved answering one simple question: is there an unambiguous sign in the text of Section 2255 that Congress meant for Section 2255H to strip an incarcerated individual of any opportunity to raise a new claim of legal innocence in a motion brought in federal court? No such sign exists. Therefore, we could have, and should have, easily concluded that there is no statutory impediment to Jones's Section 2255 motion being entertained by a court. Finally, I believe that the canon of constitutional avoidance also does important work to guide, and constrain, the court's interpretation of Section 2255 in this case. The majority's bottom line, reading the interplay between Section 2255H and Section 2255E, is that a person in prison for non-criminal conduct cannot ask a federal court to review the legality of his detention if he has previously filed a Section 2255 petition. This position is stunning in a country where liberty is a constitutional guarantee, and the courts are supposed to be dispensing justice. It also raises hackles under at least two provisions of our founding charter. First, the Eighth Amendment. There is a non-frivolous argument that the Constitution's protection against cruel and unusual punishment prohibits the incarceration of innocent individuals. This is not to say that the Eighth Amendment creates a freestanding entitlement to a second or successive round of post-conviction review. But here Jones seeks a single meaningful opportunity to have a federal court consider his claim of legal innocence. The majority's interpretation also implicates the suspension clause. The majority admits that, at a minimum, the suspension clause protects the right of habeas corpus as it existed at the time of the founding. The majority also seems to acknowledge that, in the late 18th century, an individual, even one who had been convicted of a crime, could invoke habeas to raise a jurisdictional error. Historically, the term jurisdictional when used by habeas courts meant something much broader than it means now. And, importantly, a court lacked jurisdiction and thus the writ could issue when a person was incarcerated for non-criminal behavior. Thus it appears that, by its own lights, the majority today renders an interpretation of Section 2255 that has potentially significant constitutional implications. I conclude with an observation. Today's ruling follows a recent series of troubling AEDPA interpretations. All of these opinions have now collectively managed to transform a statute that Congress designed to provide for a rational and orderly process of federal post-conviction judicial review into an aimless and chaotic exercise in futility. The route to obtaining collateral relief is presently replete with imagined artificial barriers, arbitrary dead ends, and traps for the unwary. And today's turn makes the journey palpably absurd. It begins with the Supreme Court's rare announcement that a certain claim for release exists and is retroactively available to incarcerated individuals on collateral review, and ends with the realization that only an arbitrarily determined sliver of eligible prisoners, those who have not had the temerity to file a prior motion, are actually in a position to even ask a court to consider whether any such relief might be provided. It is quite clear that the court's rulings in this area of the law reflect a general ethos that convicted prisoners should not be permitted to file Section 2255 motions or obtain post-conviction relief at all. But what matters is what Congress wants with respect to the operation of the statutory provisions it enacts. And, as I have shown, Congress's aim in crafting Section 2255 was to permit convicted prisoners to file post-conviction motions, asserting claims for collateral relief in a manner that also curbs abusive filings. Congress did not speak, one way or the other, as to what should happen if a prisoner who has previously filed a Section 2255 motion gets a new claim of legal innocence due to an intervening change in the law. Given Congress's silence on this matter, in my view, there is simply no justification for drawing a negative inference that Congress meant for Section 2255 to operate in a manner that is patently inconsistent with the reasons it passed that statute, or the background principles that animated the law more broadly at the time of the statute's enactment, or even possibly core constitutional principles. Instead, Section 2255E should be read consistent with Congress's general intent to ensure equivalence between the claims available in habeas and those that its new post-conviction mechanism allowed, to permit prisoners who have a new and retroactive statutory innocence claim to file a habeas petition in lieu of a Section 2255 motion. Alternatively, we should honor Congress's clear interest in preserving a prisoner's ability to have one meaningful opportunity to have all of his claims presented to a court, by allowing Jones to file a petition asserting his new and retroactive claim of statutory innocence, notwithstanding what might otherwise be perceived as an ironclad bar in Section 2255H. In other words, as I see it, the negative inference that the majority draws today rests on nothing, and certainly nothing that actually derives from Congress's intent. Nothing in the text of Section 2255, background principles concerning habeas relief, or AEDPA's enactment history compels, or even supports, the conclusion that Congress intended to completely foreclose claims like Jones's, and it is especially perverse to read the statute to lead to that result when doing so gives rise to legally dissonant, arbitrary, and untenable outcomes. So, the majority's straightforward determination that this statute does preclude a prisoner in Jones's position from filing a successive petition to assert a legal innocence claim, which it reaches by refusing to follow the procedural norm that would have correctly framed the issue as a matter of congressional intent relative to clear statement principles, appears to stem from the court's own views concerning finality, not the will of Congress. Ultimately, of course, this all begs the question of how, and whether, Congress will respond to the court's systematic neutering of the balanced post-conviction processes that the legislature has established. It seems to me that today's opinion, which unjustifiably closes off all avenues for certain defendants to secure meaningful consideration of their innocence claims, creates an opening for Congress to step in and fix this problem. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.